Yeah, then in this video, we look at the terms of a contract of supply of services. So contracts typically include the following terms. We have the express terms, we have the implied terms, then we have the conditions, and then we have the warranties. So the express terms, these are specifically agreed upon by both parties. It can be either orally or in writing, and they are legally binding. So express, they are agreed upon by parties and then they are put in the contract. Then for the implied terms, these are not specifically stated, but they are assumed by law or custom or by court interpretation. So the implied terms are just assumed to exist, like you assume that that term is already existing or it is already known by the other party. For example, when you get married in church, you are not supposed to tell the person you're marrying, like, we must give birth to kids or we must do this and this. Like, they already know, it is an implied term. That's why they agree to get married. So implied terms are not specifically stated. Now the express terms are those ones where you say, like, till death to do us part, like they are specifically agreed upon by the parties. But then the implied ones are not mentioned. They are just assumed to exist by law or custom or court interpretation. So they can be added by courts based on common practices or legal precedents. Conditions are major terms of the contract, and if breached, they give the injured party the right to terminate the contract and claim for damages. For example, if you hire a service provider to decorate for you and your condition is that you want a gold decoration, everything should be gold, and then the service provider ends up decorating whatever they want without following your condition, the buyer or the consumer has a right to terminate the contract and then claim for damages because that's not what they wanted. Yeah, then for warranties, these are minor terms whose breach does not warrant contract termination, but they may allow the aggrieved party to seek for damages. For example, you go to hospital and then the doctor gives you medicine and they assure you that this medicine must heal you. Then the medicine doesn't work as they told you. So that is a warranty, like they guaranteed you that the medicine is going to work properly, like you're going to be okay maybe in 2 days and then you don't. So you can sue for damages. Yeah, but you cannot terminate the contract. So that is a warranty.